I humbly request Honorable Sri Justice L. Nageshwar Rao Garu, former Judge of the Supreme Court of India, to come onto the dais and occupy his Lordship's chair. I request Honorable Sri Justice Abhinand Kumar Shavli, Judge, High Court for the State of Telangana, to present a sapling to Honorable Sri Justice L. Nageshwar Rao Garu, former Judge of the Supreme Court of India. I humbly request Honorable Sri Justice P. Navin Rao Garu, Judge, High Court for the State of Telangana and Executive Chairman, Telangana State Legal Service Authority, to come onto the dais and occupy his Lordship's chair. I request Honorable Sri Justice T. Vinod Kumar Garu, Judge, High Court for the State of Telangana, to present a sapling to Honorable Justice P. Navin Rao Garu, Judge, High Court for the State of Telangana and Executive Chairman, Telangana State Legal Services Authority. I also request Sri George Lim, Chairman, Singapore International Mediation Center, to join the program virtually. I also welcome all honorable companion judges of High Court for the State of Telangana, Registrar General, Registrars, Director, District Judges, Senior Civil Judges, Junior Civil Judges, Trainee Officers who are joining this program virtually. Now I request all the dignitaries on the dais to rise for the Vande Mataram.
Vande Mataram, Vande Mataram, Sujalam Sukhalam Malayaj Sheetalam Sasya Syamalam Mataram, Vande Mataram, Shubhra Jyotsna Pulakitayamini, Pullakusumita Drumadala Shobhini, Suhasini Sumadhura Bhashini, Sukhadam Varadam Mataram, Vande Mataram, Vande Mataram.
Now I request dignitaries on the dais to light the lamp marking the inauguration of the program. I now request Honorable Sri Justice P. Navin Rao Garu, Judge, High Court for the State of Telangana and Executive Chairman, Telangana State Legal Service Authority, to deliver his Lordship's welcome address on this occasion.
Honorable Justice Ujjwal Bhuyan, Chief Justice, State of Telangana, Honorable Justice L. Nageshwar Rao Garu, former Judge of Honorable Supreme Court of India, Mr. George Lim, Chairman, Singapore International Mediation Center, my dear brother and sister judges, press, and print media, judicial officers participating virtually, registrars and staff of the High Court. Good afternoon to all of you. Art of mediation and negotiation in dispute resolution process, concept and techniques of mediation. This is our motto of assembling here for the next 3 days and deliberate and discuss, debate and go forward of encouraging the mediation. I start by saying what Mahatma Gandhi said in his story of my experiments with truth. He was sharing his experience when he was practicing in South Africa. My joy was boundless. I had learned the true practice of law. I had learned to find out the better side of human nature and to enter men's hearts. I realized the true function of a lawyer was to unite parties riven asunder. The lesson was so indelible burnt into me that a large part of my time during 20 years of my practice as a lawyer was occupied in bringing about private compromises of hundreds of cases. I lost nothing thereby, not every money, certainly not my soul. Unquote. Now, though he was talking about a lawyer, but I would say that same thing may equally apply as a judge of High Court. As we know that in the subordinate courts, we have 8,40,000 cases pending, and in the High Court about 2,40,000 cases pending. It's not possible to dispose of these cases, even how much we work hard and how much of time we devote. So therefore, we need to evolve new mechanism and methods to see that the cases are disposed of as early as possible. In the High Court itself, we have cases pending for several cases pending for more than 10 years. I would say even there are many number of cases which are pending for more than 20 years. So it's not possible for us to plan and dispose of these cases in the normal method of disposal. Several hurdles will come, more particularly for old cases. The hurdles will be more like either some of the parties have died, we have to bring their laws on record, that will take its own time. Many times even the councils are no more. So these are the problems we face, to say the least. So therefore, we may have to evolve some mechanism to ensure that the cases are disposed of at a faster pace. As we know, conflicts are unavoidable in any society for a plethora of reasons: individual, social, economical, political, cultural and religious. And as such, there is a need to develop mechanism for conflict resolution. India, unlike other countries, have a long and rich tradition of collaborative and amicable settlement of disputes. Mediation in varying forms existed in India since time immemorial. The magnum opus epic Mahabharata actually illustrates an example of early attempt at mediation as a conflict resolution tool, where Lord Krishna attempted to mediate the dispute between Pandavas and Kauravas. And it is worthwhile to recall the failure of such mediation, which led to disastrous consequences. In India, from time immemorial, various forms of mediation was practiced as a method of dispute, conflict resolution. In villages, elders assisted in resolving the disputes by providing their wise counseling. I was witness to many of the disputes being resolved by my father, as he was a sarpanch for about 20 years. So in the childhood days, I used to cleanly observe how the proceedings were taking on, how the elders were advising the persons who are in conflict. Concept of mediation, as we know, mediation is a voluntary, party-centered and structured negotiation process. It is a flexible settlement technique which is conducted privately and confidentially, in which the mediator acts as a neutral facilitator to help the parties to arrive at a negotiated settlement of disputes. The development of mediation as an ADR mechanism can also be attributed to Section 89 of the Code of Civil Procedure, which was inserted by the Amendment Act 1999 with prospective effect from 1/7/2002. In the various legislations made in the recent past, the precondition imposed is that the parties must first take recourse to the mediation, and then only they should come for litigation to the regular courts. One example is from the Commercial Courts Act. Section 12A was inserted to encourage mediation as an important tool before the persons having commercial dispute to take recourse to the regular courts. The Honorable Supreme Court, in the case of Salem Advocates Bar Association vs. Union of India, made it mandatory for the courts to refer cases to the alternative forums if they were so pleased. This case stands as a landmark in the development and evolution of mediation in India. Honorable Apex Court in Food Corporation of India vs. Joginder Pal also laid down the emphasis on ADR system of adjudication through arbitration, mediation and conciliation, and is a modern innovation into the area of the legal system which has brought revolutionary changes in the administration of justice. Further, Law Commission of India in its report number 222 of 2009 emphasized the need for justice, dispensation through ADR, etc., recommended that there is urgent need for justice dispensation through ADR mechanism. Apart from increasing legal awareness, the National Legal Service Authority encourages settlement of disputes through ADR methods. One such mechanism is the Lok Adalat and another is mediation. At present, mediation centers are functioning in 10 districts in the state of Telangana and one at High Court level. Consequent to the establishment of new DLSS on par with the newly created judicial districts, Telangana State Legal Service Authority is taking steps with the government of Telangana for establishment of mediation centers in the newly established DLSS. The matter is under active persuasion and we hope to have soon mediation centers in all the districts. Mediation centers in the state of Telangana are presently dealing with court-referred mediation, especially in matrimonial disputes, property disputes, family matters, as it is simpler, quicker, party-centric and neutral procedure to get an amicable settlement. We have with us two eminent persons who will be interacting with us now. Justice L. Nageshwar Rao, as you know, has been a successful practitioner at law in our High Court and before Honorable Supreme Court, before he became a judge of the Supreme Court. And as a judge of the Supreme Court, he stands of delivering landmark judgments. Post-retirement, Justice the SC bench led by Justice Chandrachud tasked former SC Judge Justice Nageshwar Rao with amendment of the Constitution of India Olympic Association. The bench was hearing a plea claiming the association had government issues such as failure to conduct elections for office bearers. Justice Rao proposed an amendment which states that there will be an equal number of male and female members with voting rights in the IOA. On November 10, 2022, the bench ordered the IOA to formally adopt the amended constitution and held that the elections would take place as planned a month later on December 10th. Justice Rao, member of the Board of Trustees, International Arbitration and Mediation Center. He has rendered several notable judgments. I do not wish to refer to them at this stage and leave the podium to the two distinguished guests we have today. Sri Judge Lim was called to the bar in Singapore in 1981 and has practiced law for more than 40 years. He was appointed as senior counsel by the Chief Justice of Singapore in 2010 and was president of the Law Society of Singapore between 1998 and 1999. In January 2017, Judge was appointed chairman of the SIMC, Singapore International Mediation Center. Judge has mediated more than 700 disputes and has extensive experience in mediating cross-cultural, cross-border disputes in Singapore, Thailand, Taiwan, Maldives, South Korea, Australia, and Fiji. Judge has also conducted mediation training for judges and lawyers in Singapore, Thailand, Philippines, Malaysia, Dubai, Bahrain, Maldives, Hong Kong, South Korea. Was in Hyderabad Center also. Judge on the panel of arbitrators of the Singapore International Arbitration Center. He is a dispute resolution counselor of the national electricity market of Singapore and manages the dispute management process of the energy market. Between 2009 and 2010, Judge served as the first chairman of the Asian Mediation Association. In 2013, he co-chaired a working group appointed by Chief Justice Sundaresan Menon and the Ministry of Law to make recommendations on developing Singapore into a center for international commercial mediation. Judge was Singapore's mediation consultant in UNCITRAL Working Group 2, which led to the adoption of the Singapore Convention on Mediation in 2019. In October 2019, he was appointed to the roster of panel chairs of the Comprehensive and Progressive Agreement for Trans-Pacific Partnership on Dispute Settlement. In 2020, Judge was awarded the Public Service Star by the President of Singapore for his contributions to mediation. In 2022, Judge was named by the International Who is Who of Commercial Mediation, thought leader in mediation. He is the co-editor of Mediation in Singapore, a practical guide. I welcome both of them, and I hope that we will be enlightened by their thoughtful interaction, with their thoughtful guidance to us. Online, the newly recruited judicial officers are also participating. I request those judicial officers to pay special attention to whatever is debated today and for the next 2 days. You are the future, and then we are to imbibe the scope of how to allocate mediation process, mediation of disputes. Thank you so much.
Thank you, Miller, for your valuable message. Now I request Sri L. Nageshwara Rao Garu, former Judge of the Supreme Court of India, to address the gathering.
Chief Justice Bhuyan, Justice Naveen Rao, all other brother judges of the Telangana High Court, judges of the subordinate judiciary. George, I don't see you. Is he there? Has George joined? Has he joined? Hi George, good afternoon. Good afternoon to all of you. Why should there be training for judges? Especially training in mediation. What are you going to do with mediation? Some of you must be thinking, why has Naveen Rao and the Chief Justice brought you here? So making you sit here, say, waste your vacation and then spend 3 days trying to learn something which you are not going to do. So some doubts like this might be coming in your mind. As I am addressing not only the High Court judges but also the judges from the subordinate judiciary, when I say something, I'll try to separate the subordinate judiciary from the High Court judges who are physically present here. When I said this, I'll start off with the subordinate judges as to how important mediation is for discharging their duties, and as to how mediation is very relevant and important for High Court judges also. And High Court judges have to learn about the mediation for the purpose of propagating mediation, because you are the persons who are well respected in the society. People look to you for guidance. You are the leaders insofar as conflict resolution is concerned. If you have to think about rule of law, if you have to think about access to justice, you have to think about ADR. When you think about ADR, it's not only arbitration that is an important mode of settling disputes through ADR, but mediation is a very appropriate dispute resolution mechanism. When I spoke about rule of law, You might be wondering what has rule of law got to do with this mediation. The rule of law, as spoken to by Thomas Bingham, is persons getting a day in court, persons knowing that there is equality, persons who are litigants going to court for impartial justice and for effective resolution of their problems, in England by judges who were wearing wigs. So we are persons who have stepped into their shoes. When a person comes to court, when he is speaking of rule of law, he wants you to adjudicate a dispute which is brought before you. So there's nothing like ADR, which was spoken to by Thomas Bingham to start with when he said rule of law. But one core component of rule of law is access to justice. So he said that every person should have access to justice. So in this country, we have given a lot of importance to access to justice. This being the largest democracy, we take pride in saying that every person in this country has an opportunity of redressal of his grievances. He can approach the court for violation of fundamental rights, for settlement of civil disputes, or whatever problems that he has. He can go to court. There's somebody who's going to hear him and then try to find a solution for his problems. Is access to justice possible with a number of cases that Justice Navin Rao was pointing out in this particular state? He just said that the High Court and subordinate courts put together, there are 10,80,000 cases that are pending. Is access to justice possible with so many cases pending? To a common man, I'll tell you my own experience being in the legal profession for so many years and being a judge. Whenever somebody close to me, known to me, a friend, a relative, a member of the family was asking me for an advice that I have a dispute, should I go to court? I used to say, please don't go to court. And they used to ask me, you're a lawyer, you're asking us not to go to court. So I used to warn them, if you are willing for a test match here is not 5 days, 10 years or 20 years of litigation, lose sleep over your matters, there being no peace of mind, you can go. Otherwise, try to avoid going to court. It's not a very pleasant experience going to court. Being a judge and a lawyer, I shouldn't say this, but that's how it is in this country. That's the reality. That's the truth. All this is because of the courts opening doors to everybody, which it should, and providing access to justice to every citizen in this country. We have about 5 crore cases pending in this country. And according to Niti Aayog, it's going to take 326 years to wipe out the arrears. There is no new case that is filed after today. It's not possible. It's humanly impossible. All judges work. All judges take oath that they would work. They work to the best of their ability. If they are not answering their conscience properly. All of us are supposed to work. All of you, I am a retired judge now, all of you are supposed to work. This is what you have been appointed for. In spite of your working overtime also, it's for these arrears. When I became a judge, because I didn't become a judge like you in the high courts, I had this handicap of being directly elevated to the bar. I was asking for some advice to retired chief justices and judges, saying that how is it that I proceed to work as a judge, because I haven't had the experience like all of you who have come here, or they come here with 10 years or 15 years of experience. The universal advice that came to me was this: if you think that you are clearing the arrears by working overtime and disposing of cases, that's a myth. You can dispose of as many cases as possible. Next day there will be double the number that are being filed. You can only do as much as possible between 10:30 to 4 o'clock. So that's the time that is given to you. So you work to the best of your ability. That's the advice that I got from my seniors, senior judges rather. So in spite of your working to the best of your ability, you will not be able to dispose of all the cases. Where will the common man go? As of now, this is the only reason which the common man in this country has some respect, some belief that there will be some justice done to him. If we are not able to provide justice where he will get some relief immediately, where it will be inexpensive, where it will be impartial, the common man might turn their eyes to some other methods, which is not good for a democracy. That is the reason the Law Commission started making recommendations that there is a need to find out alternate dispute resolution mechanisms. For what? For providing access to justice, not only to courts, to other fora for resolution of their disputes. That's how we started speaking about arbitration, started speaking about conciliation, negotiation, judicial settlements, by determination by courts, as well as mediation. There were Law Commission recommendations that were made as to how important mediation is and as to how alternate dispute resolution mechanisms have to be given an impetus. In 2005, the Mediation and Conciliation Project Committee was formed by Chief Justice Lahoti, as he then was. They started a pilot project in Karkadruma courts in Delhi. They got judicial officers, 40 judicial officers trained by ICDAS. They underwent the training, and this was sometime on 9th of April, MCPC was formulated or was formed in 2005. In September, the judges in the Karkadruma court have started a court-annexed mediation center in Delhi, whereby courts were referring matters to mediation, and the court-annexed mediations with the help of members of the subordinate judiciary. Lawyers were not there at that point of time in the scene. So they were the ones who were doing mediation to settle disputes. Initially, mostly there were matrimonial disputes and some small property disputes. And thereafter, the disputes, they have gone into the other areas also, like commercial, etc. When Justice Karju was the Chief Justice of the Delhi High Court, he proposed that the Delhi High Court should have a mediation center. Actually, when he was Chief Justice of Madras, he started that mediation center there. The mediation, court-annexed mediation center of a high court was first started in Chennai. And thereafter, when he went to Delhi, he proposed this. He wanted the cooperation of the Bar Association. Mr. Chandyok, who was the president of the Bar Association, he said that unless we have an equal say in this organization, which we are going to set up, that is the court-annexed mediation center, we are not going to cooperate. In those days, now there is a slight change. Members of the legal fraternity seem to be the main villains for any ADR because of some sort of a feeling that it's going to have a hit on their pocket. But the Bar Association of Delhi High Court took an active interest in starting the High Court Annexed Mediation Center, which was named Samadhan. Samadhan from 2005, after 2007-8 onwards, it has been doing so well. Every day it has 100 to 150 mediations. It's like a regular court where trained mediators mediate matters in the facility that is available in the Delhi High Court. And the success rate is about 65 to 70%. The court takes an active interest in referring matters of mediation to the mediation center. And the mediation center has been very successful in mediating matters. The same is the case with the mediation center in Bangalore. It also has a good success rate. But the same can't be said about the court-annexed mediation centers in the other high courts. Why is it that the mediation centers, court-annexed mediation centers at least, have not been doing well in the other parts of the country. This is because of the lack of awareness amongst judges, especially referral judges. You must be knowing, you must have seen these judgments, the Salem Bar Association cases 1 and 2, where there was an amendment to CPC, and then all of you know about section 89 CPC, which was brought in for the purpose of ensuring that the judges apply their mind before the issues are framed, and then find out whether a matter can be settled through ADR. It was not being taken seriously. The problems relating to interpretation of Salem Bar Association 1 was taken care of in Salem Bar Association 2, and thereafter Justice Ravindran in AFCONS, he actually laid down the roadmap as to how referral judges are to take their decisions in matters that are pending in courts, civil disputes. Referral judges have become very important in promoting mediation or any other alternate dispute resolution in this country, which was recognized by the MCPC. That is the reason why they have released a handbook for referral judges. I request Justice Naveen Rao to get that handbook. I'll give a copy of that to him, distributed to all members of the subordinate judiciary in this state. That serves as a guide as to what they should do, what they should not do, how they should go about it. So there is an imperative to go through that handbook that is issued by the apex body for mediation in the Supreme Court, that is the Mediation and Conciliation Project Committee. It is so important for referral judges to understand why disputes have to be sent to mediation. Why can't they be decided in court? I told you the main difference between an adjudication, arbitration is also adjudicatory in nature, because you appoint an arbitrator and then he almost conducts a court. There is evidence that is recorded and he hands over an award, hearing parties, etc. But mediation is a completely different process altogether. Mediation is a voluntary process where you have a third party only assisting you to resolve your disputes. You here is not the judges, you is the party who is coming with a problem to court. So 89 imposes an obligation on a judge to find out whether there is a possibility of a settlement at that stage, and even if it is not done before issues, which has to be done, the court is not disarmed from sending a matter for mediation even after the issues are framed. So nobody stops from the court from doing it. In view of the large pendency of cases and in view of the time that is taken for disposal of cases, if you are thinking about the litigant who is coming to court, at least to de-escalate the growing number of cases in courts, the first thing that should come to the mind of a judge, a subordinate judge, when he is looking at a freshly filed suit is, yes, call the parties and tell them, you please go and then get this matter settled. If you want to go for arbitration, if there's an arbitration agreement, you go for an arbitration. If there's no agreement, why don't you go and then try for a conciliation or a mediation? So this is something which has to be mandatorily done by a referral judge. He has to look into the cases which can be or which can't be. There are only a few cases which can't be referred, like an Order 1, Rule 8, or all disputes in REM. They can't be criminal matters, etc. But all the other matters can be referred for mediation. So if you take this much interest in ensuring that there is a move that is made by you, the parties would definitely lead and then they go before a mediator. The problem, as I understand, in the other parts of the country, apart from Delhi and Bangalore, is that there is a lack of trained mediators. This is appearing to be a serious problem, that you do not have trained mediators. MCPC has given guidelines where they say that a trained mediator would be one who undergoes 40-hour training, and then he has done about 10 mediations. He will be a person who will be fit for handling a mediation. But I'm sorry to say that even the Supreme Court Mediation Center has some mediators who say that they are trained, but trained by whom? Which organization has trained them? They go to some private organizations, pay a lakh of rupees and then get a certificate. But they're really not having the material or the metal to take care of any mediation in a proper manner. Mediation, as we all know, it might be very easy to say that what is there? Panchayats have been doing it. People who have disputes, they come before them, they settle it. They are all very wise men, they were settling it in a different manner. But now, unless you get trained in mediation or the techniques in mediation, you would not be a good mediator. I come back to the first question I put to you. You are not going to be mediators, so why should you be trained? Let me tell you, I spoke to your trainers who are going to come and speak to you tomorrow and the day after. They have prepared this capsule not for the purpose of training you as mediators, but only for the purpose of making you aware about the importance of mediation. So you are not going to be told what all is going to be taught to mediators. I spoke to them. Why is it important that you should learn is for this reason. Unless, I'll tell you about my own experience. I have been a judge of the Supreme Court for 6 years. Except for matters pertaining to matrimonial disputes, it never occurred to me that other matters which have been pending for 20-25 years, where there is a possibility of settlement, can be sent for mediation. Never occurred to me. And nobody told me also. Even the lawyers also were not making the submission, why can't we send this for mediation? Only when I was appointed as executive chairman of MCPC, I started thinking as to why even complicated matters cannot be settled. There are instances. You have George Lim online. He has settled about 700 disputes. He settled a $5 billion dispute through mediation between a company and South Korea. And all these happened in a period of, within a span of 2 days. So if cross-border commercial disputes which involve huge amounts of money can be settled like this, why can't commercial matters in this country be settled? So there is a need for our mindset changing, that courts are meant for adjudicating complex issues, especially constitutional courts. You are there to decide matters which can't be sent for mediation. You need an adjudication. You need to give an opinion. So that's the reason that you should be able to spend time on these disputes. After retirement, I had the opportunity of traveling all over, meeting judges from various other countries. When they asked me, how many cases do you do a day? And when I told them that I handle about 65 to 70 matters a day, they were thinking that I was joking. 65-70 matters is what they do in months. I know how many matters must be listed before you. I left this place a long time back. Then itself there were 65-70 matters. Now you might be having more than 100 matters on your board every day. So people will go mad from outside if they know that each judge has this much workload. So it is not possible to deal with these matters on the basis of quality if you are only thinking of quantity. You see, there is so much pressure on judges that every person comes and then says, hear my matter. And then they want the matter to be heard immediately so that he'll either not get an interim order. And with this amount of pressure in view of the burgeoning docket, so when is it that we are going to do justice? So, all the judges in this country should start thinking that these are the cases which are fit to be decided by adjudicating these disputes in courts, and all others, there is a need that these matters have to be sent to some other alternate forum for disposal. There is no dearth for work. I've been telling bar associations and lawyers, it's a myth that they're not going to have work. In spite of this country having 25 lakh lawyers, you just see the number of cases that are pending. Everybody will have work. Merely because matters are disposed of, it's not as if people will not come. If they find that matters are getting resolved early, there will be people who would want to get their disputes resolved. Even the perspective of a lawyer in the world has changed. Only in this country we don't think on those lines. A lawyer is now seen in the Western world as a conflict manager. A lawyer is not only a person who goes to court and then argues cases. He is supposed to be a person who understands conflict resolution methods better. Who what is the things which every lawyer has? But it is very important that even if for judges in the appellate courts, I'm sure you must be having first appeals which are pending for years together. 10 years, 15 years, I'm not sure how many years. 20 years. 20 years first appeals are pending. And even second appeals which can be decided on a question of law must be pending for a long time. So, that speaks of what the civil court has to do. There is no bar for the High Court judges also to think of this method of resolution dispute by mediation. Because that's what even the Supreme Court is doing. A dispute which has been pending for 40 years. Yesterday, I didn't know that I was handling such a dispute. The amount involved in the dispute is 1,000 crores. And members of a royal family are fighting for 40 years. The Supreme Court asked me to mediate that dispute. So, it need not be necessary that, oh, matters have been going on for a very long time. Why should we send this for mediation? So, the problem with any conflict is, whenever there is a long period of time, it becomes very difficult for the matter to be settled. The conflict cycle becomes much more difficult. If you are able to get it resolved at the initial stages, that's why I was talking to the subordinate judges, telling them, please think about 89 is there. Use it. And then if you can stop it there, that's the best thing that can happen. It's not going to escalate much. But first appeal. Okay, 10, 15 years has passed, still you can do it. If the Supreme Court is doing it, why is it the High Court cannot do it? So this is not going to be told to you tomorrow in your training. That's why I thought I'll take the opportunity and then tell you, as a retired judge, that the High Court judges as well as the subordinate judges have to start thinking that it is really necessary at this stage to at least ensure that the public confidence is continuing in this system, that we'll have to offload unnecessary things, unnecessary cases that are engaging the attention of courts. How much of time is being wasted? So, for that, I'll tell you why mediation is the most appropriate resolution mechanism. There is a debate as to whether parties should be forced to go for mediation. Only willing parties, because only two parties say that, okay, we will go for mediation and settle our dispute. That's how, it's a voluntary process is what we call. There are some countries where they believe that parties can be asked to go for mediation, making it mandatory. You go, you try for a mediation. If it doesn't work, it's all right, leave it. But otherwise, don't say that you will not go. Australia imposes a fine if you don't go for mediation. But I feel that might not be possible in India. Mandating a mediation and that mediation process being voluntary might be an oxymoron. But still, you can persuade parties to go. So when we see with our experiences, all of us know, especially in the Supreme Court, when we are dismissing an SLP, immediately the lawyer says, can we try mediation? Living for another day. He also knows it's not going to happen. So with your judicial experience, you know whether a party is serious or not. But if a matter is pending for years together, giving them another opportunity for 4 weeks and sending them before a trained mediator is not going to really matter much. So the first point which I said, that why is this training required? It's only not for you becoming trained mediators, because you're not going to be mediators right now. you have other duties to do. But otherwise, for your understanding that there is a necessity of alternate dispute resolution mechanism to be invited, then to be entertained, to be promoted, because you are the persons who are going to provide impetus to this mediation or arbitration being a tool of effective dispute resolution. How is it that you are going, what is it that you are looking forward to tomorrow? What is it that you are going to be spoken to about mediation problems, etc.? I underwent 2 mediation training courses of 40 hours each after retirement. What you would be told is that a mediator is a leader. So how is a mediator as a leader? What is it that a leader is? What are the qualities of a leader? Though a mediator is not going to give any suggestions to the parties, he is not going to tell the parties the manner in which they decide, he only facilitates an agreement. In India, we only practice facilitative mediation, we don't do evaluative mediation, but still, he is the person who is guiding the parties to settle their dispute. So the leadership qualities of an individual is what is very important. And what are the other qualities which are there, which are necessary for a mediator? Empathy. Empathy is different from sympathy. Empathy is trying to understand the position and difficulties of the other person. So empathy is a very, very important quality of a human being. You must have heard a number of times whether you are empathizing with the cause of others or whether you are only selfish thinking about yourself. What is it that you are doing when you are hearing another person? So this is what you would be learning. And the most important thing that you will be learning is art of listening. See, I was just thinking about this when I just said art of listening. When lawyers are impatient in court and fighting, we as judges, we tell them that being impatient is a prerogative of a judge and not lawyers. They can't be impatient, only we can be impatient, is what we tell the lawyers. But ladies and gentlemen, art of listening is a very difficult art, especially judges in the constitutional courts. We get to blabber a lot of times. So, for various reasons, you have unreasonable lawyers appearing before you. To stop them, you raise your voice. Everybody has his own technique. There are some people who talk more, there are some people who don't talk at all. It all depends on an individual, but otherwise, not tuned to the art of listening. Why are they not tuned? Because of the pressures that they have, because of the situation that they are placed in, because of the list that is before them, which keeps telling them you have to complete this list by evening. There's so many other things, but otherwise in life also, art of listening becomes very important. For a husband to listen to the wife, for a wife to listen to the husband, to understand what they say instead of just shouting them down or trying to make your point